but it does really mean making sure young people have access to kind of age-appropriate activities, experiences. And we know that youth in foster care face a lot of challenges with that, but youth with disabilities face additional challenges. So while this provision about including advocates in case planning is related to normalcy, those advocates can obviously be involved in other areas related to case planning and service provision. So just something where you might be able to use as a way to get involved in and provide advocacy in some planning. And then I mentioned that age of 14 has become even more important in child welfare law, and as I mentioned on the last slide, that it's about consulting youth in transition planning and case planning in general, which I think goes beyond the transition planning. But the Child Welfare Agency must start providing and focusing on these services around age 14, and then be putting what those services are and the needs that young people have in the case plan that is developed and is something that's required by law. The transition plan culminates in, and I know those words, we use transition a lot. Like I said, young people should be getting transition services starting at age 14. The transition plan, which we think of as like that endpoint, that discharge plan, is also something that must be developed with the young person before they leave the child welfare system. And so this is the federal law requirement that at least 90 days prior to discharge from the child welfare system, when a youth is 18 or older, so whenever that endpoint is, that there must be this transition plan. And what is distinct, I think, from the discharge transition plan, the end of the road plan, is that you really have to have specific plans that have specific elements and options around things like health insurance, housing, education, employment, mentoring, and support services. And a lot of those elements are so crucial for all youth, but I think particularly for youth with disabilities, all of those elements are part of pieces in a plan that we need all the pieces in place to really make the plan work. The federal law also requires that we think about healthcare decision-making options. So again, just being aware that these, while you guys are probably most aware of these things as just good practices, that the federal child welfare law really does require that these things occur. I do want to note, we want to give, because we know we're talking to an audience of practitioners from across the country, so wanted to focus on federal law, but did want to highlight to you all that the federal law transition planning requirement really, most states have parallel requirements. And what is helpful about some state laws, and we definitely encourage you to look into what's in your state, is that many states have specific transition planning requirements that prohibit the Child Welfare Agency from discharging youth if they don't have an acceptable transition plan. And in some examples later in the presentation, we'll show you how in some states that has really been, when advocates enforce that law, they really have been able to stop discharges to bad outcomes and really have been able to force and incentivize the provision of services and good planning. So you really do, you want to start from this federal law provision, but know what's in your state. So my state of Pennsylvania, we do have court rules that say you can't discharge without a transition plan. New York and California have similar provisions, and we know there's a bunch of other states that have those provisions as well, and they can be really great legal tools for you to use as advocates and also use in partnership with some of your child welfare colleagues. And so a new provision of the law, and this is about 2 years old, from the Strengthening Families Act, is that the federal law does require that before young people are discharged from the child welfare system, that they need to be provided copies of their vital documents. So what's listed on this slide in terms of birth certificate, social security card, state ID or driver's license, health insurance information, including any cards or documents needed to access healthcare and medical, as well as medical records. Those things are really vital, I think, to transition planning, and to know that there is a legal obligation to provide these documents and pieces, I think, are helpful as we're doing advocacy and transition planning with young people. As I noted, another really important element to know about kind of how you assist youth as they transition is extended foster care. And when we say extended foster care, what we're talking about is the option for young people to stay in the child welfare system until age 21. The federal law in 2008 allowed states to receive federal financial assistance if they did extend care to 21. At this point, about 2/3 of the state do that, and so you do want to know if your state provides extended foster care, because again, it can be a really vital tool both for providing support as youth transition and also just for giving you more time as you do the transition planning. And we're happy to help if you don't know what's happening in your state and want information about that, what the status of extended foster care is. Please do email us and we will give you the information you need. Another thing that's really helpful for all of you, regardless of what state you're in, is that the federal law does obligate the Child Welfare Agency to provide aftercare services to kids who age out at 18 until they're 21. And why that's helpful is it doesn't matter where a young person was in foster care and then where they end up. What is clear in the law is if Penny was in foster care in Pennsylvania, aged out at 18, and moved to Ohio. Maybe she moved to Ohio because she wanted to go to school there or live with family or take a job. If she was in foster care at 18 in Pennsylvania and now is residing in Ohio, Ohio must provide her independent living services. What they provide will depend on their array of services, but it definitely can be a vital resource for you if you're working with a young person and you do want to find some services for them. Each state has what you call an independent living coordinator. I know that independent living is also a technical in term of art in the disability world. It is also one in child welfare, although we're kind of moving to transition to adulthood rather than independent living. But that term CHAFE-EIL coordinator is still something you'll hear, and each state should have them to find out, if you're working with a young person, what they provide in aftercare. Another key benefit that youth aging out of foster care have, and again, regardless of where they're currently living, is this education and training voucher, which is up to $5,000 to help pay for the cost of attendance with higher education or training. It's an array of different post-secondary options, and it can be really vital in piecing together your transition plan because it's not just for tuition, it's for cost of attendance, so it can really help fill in some gaps that a young person might have as they're putting together their plan. We did want to highlight to you all that over the last 10 or so years, many states and institutions of higher education and training have started to put together targeted programs for youth who aged out of foster care. Some states have tuition waivers. Other states have foster youth specific campus support programs. The two links on this slide will help you navigate two maps that will tell you what you have in your state. And again, they can be really vital sources of support as you're piecing together a transition plan. Another thing we just wanted to highlight in terms of planning for the transition is that any young person who was in foster care at age 13 or older will be considered independent on the FAFSA. So this is really key to accessing financial aid in higher education and training. So again, we just wanted to highlight that. As Karen mentioned, we did an earlier session on planning for education and higher education where we have more details. So please do refer to that, but also email us questions if you want more details on some of these benefits. And then another really crucial element of federal law, which we are really hoping sticks around, is Medicaid to age 26 for former foster youth. So if you're working with a young person who was in foster care at age 18 and enrolled in Medicaid, they're categorically eligible for Medicaid until 26, regardless of income. It's a really important provision meant to really give parity to youth in foster care, give them parity in relationship to kids who grow up in families and can stay on their parents' health insurance. Again, this is a really vital, I think, in piecing together the transition planning and making sure that young people have health insurance when they leave, which can be really challenging for that age group of mid-20s, early 20s. And we wanted to put on this slide, we have a link to our website, which we have a list of kind of how kids apply in all of the different states. And we're also happy to answer questions if you have more questions about Medicaid to 26. So I'm going to shift it over to Karen to talk about some other key programs and benefits to support youth in their transition that are available to youth in the child welfare system, but come from other sources of law, many of which you guys will be very familiar with, but often youth in the child welfare system aren't connected up with because child welfare is less familiar with them.
Thanks so much, Jenny. Yes, and as Jenny mentioned, we're often giving presentations for primarily child welfare audiences where a lot of these things that I'm about to share with you guys are really new information or information that they've heard of that's unfamiliar. These are things that probably won't be that way for you, so I'll go ahead and give you, here are the things that I'm going to be covering as sort of parallel legal requirements, things that need to be part of transition planning for young people in the child welfare system who have a disability that are often overlooked as part of the child welfare transition planning process or underutilized or just aren't leveraged to the full degree that they could be. So I'm going to talk about each of these, not so much to tell you exactly what they are, because I think that you're probably, many of you, and it's fine if you're not, but many of you are coming from a higher level of familiarity with these things. But I want you to be thinking about, and we'll get into in the next section of this presentation, what policy and other advocacy strategies can we use to ensure that these things are done in parallel and that we are able to maximize both the services that Jenny just mentioned. She went through a whole host of legal requirements and services that should be provided through child welfare, but how do we ensure that those are aligned and done in parallel with these services as well that are outside of the child welfare, they aren't child welfare specific, some of which then are able to continue into adulthood and so can really are vital to ensuring that there's a smooth transition as young people are aging out of foster care. So we're going to walk through a little bit on the IEP transition services and how those can be aligned with child welfare, accessing SSI for kids in foster care, what Medicaid waivers, how they might play into the transition planning process, and then a little bit about new requirements for vocational rehabilitation that can be an important tool, again, for child welfare advocates and disability advocates working with young people in child welfare. So Jenny talked to you about the elements, the federal requirements for transition planning. And I want to point out that for those of you who might do some special education work and are familiar with the IEP transition planning requirements and transition services requirements, these are things that are in the federal IDEA that all young people who are receiving special education above age 16 or perhaps younger in others in certain states are entitled to be receiving through their IEP. There is an overlap between what's in those IDEA requirements and what's in the child welfare transition planning requirements. Specifically, the three domains, as many of you might know, for IEP transition planning are education, post-secondary education and training, employment opportunities, and independent living. Here, independent living kind of meaning the disability term of art, so perhaps a focus on young people with intellectual disabilities or those that are needing particular skill sets to be able to sort of live in the community independently. But again, we have an independent living requirement in child welfare. Many of the services look similar, and there should be some parallel provision of services and alignment of the goals in each of these domains. So each of these things are present in child welfare transition planning requirements, and I think can be most powerful and most effectively leveraged for the benefit of an individual client when there is when these things are happening in parallel, when the same sort of team of people might be part of the IEP transition planning process and also the child welfare planning process, and there's some coordination of these services. Too often we see that they sort of happen in isolation, that maybe there's either a different set of goals or not matching services, or unfortunately in many instances just very weak transition plans in the IEPs for young people who are in foster care. One reason that we don't see sort of maximum benefit of your maximum utilization of IEP transition planning services is that a particular barrier for kids in foster care is that they don't always have an active engaged parent serving as their parent or surrogate parent role for purposes of the IDEA. So that's one really kind of key advocacy step or action step for anyone working with a young person in the child welfare system, is to find out who their education decision maker or surrogate parent is. Who is the one that is legally empowered to make their education decisions, both for special education purposes and perhaps also more generally in terms of school enrollment, other purposes. And make sure that that person has been identified for the young person. And if there needs to be a court order appointing somebody to be the education decision maker, ensuring that that happens, because without that, you really can't leverage the full array of services they might otherwise be able to. In recognition of the kind of particular challenges that young people in child welfare experience in trying to maximize the services available through their IEP, we, in collaboration with the Disability Rights of Pennsylvania and the Education Law Center here in Pennsylvania, work to put together a toolkit that is actually, it's available in the handouts that are downloadable in your control panel of this webinar. We're also happy to send them out afterwards. And this link here on this website on the slide will also take you to the website where you can download it. I'm going to spend just a minute walking through what the toolkit is. I think that it's something that we designed a little bit with child welfare or juvenile justice advocates in mind, but is definitely applicable more broadly than that. So I'm going to spend just a minute. Let me exit out of the presentation for a second to be able to show you what I'm talking about. Okay, so hopefully you're all now seeing this document entitled Developing an IEP Transition Plan, and you'll see the title. It does say that it's for Pennsylvania youth. I will tell you that the only thing in here that is really Pennsylvania specific is that here we do have a law that requires that IEP transition services begin at age 14 instead of 16 as required by the federal law, but that is, I think, the only state-specific thing that's really in here. And the idea here is that a lot of times young people in child welfare both don't have the active, engaged education decision maker or surrogate parent, and also the people that may be helping them in the process of education planning and planning for adulthood aren't necessarily as versed in the options that are available through the school district or through their IEP. They just don't know what's out there. So it's hard to imagine what they might be able to help advocate for in an IEP planning meeting because they aren't special education advocates. They don't have the same array of knowledge that that somebody else might have bringing to it, or the same investment that a parent might have in really understanding the individualized needs of the child. So this is just the overview page that tells you what the toolkit's about, and this is sort of a checklist of all the information that you might need to have to help a young person sort of identify some goals, to know where they are currently, and be able to, again, take somebody who you might not, who an advocate might not have been working with for years and years, but still have enough information to help them plan. But really the thing I wanted to highlight for you are these 3 worksheets. So one is for setting employment goals, and the idea here is as you walk through these questions, it sort of prompts a robust goal-setting process of really thinking about how, not just saying, okay, the goal is to work, but what specifically, and how did you come up with that, and what skills would be needed, and does the child have these skills, and if not, what services might we be able to put in place to help them get there. And so the box here at the right is sort of designed to trigger some ideas that might be things you'd include, and the questions here on the left are designed to sort of help guide that process and have a good, strong conversation with the young person before going into a planning meeting. And we have they vary slightly, but they're similar structures for post-secondary education and training, and then for independent living. So these are things that we really encourage people to use, to adapt. If you want to make a specific version for your area, and you'd like to sort of modify what we've done, send me an email. I'm happy to help with it. But we hope that it's something that really facilitates this kind of cross-disciplinary planning, and that can really leverage what's available through the IEP transition planning process.
And one of the things, I just wanted to add that if for those of you on the phone who are P&A advocates and you are trying to engage either the child welfare system or child advocates in your community, as Karen said, we're happy to have you use that tool as a way to say, hey, we want to train you on this tool. We want to collaborate with you, and this kind of gives you something to share with them. You guys probably have plenty of materials to share as well, but sometimes just having a kind of reason for either coming together to share the information, but also giving them some things they can use to really implement some of the stuff you are sharing with them. As Karen said, we're happy for you to use this tool or to modify it as you see fit, because I do think this is an area where there can be lots of really great child welfare P&A collaborations that really do use each of your kind of strengths and knowledge bases, and we're happy to help with that as well, because we have really found, as Karen said, and as we said in the education webinar, that youth in foster care that were really underutilizing their transition plans, and that that is such a vital tool, in part because some of their placement settings are really not getting a lot of the experiences that a lot of youth we may take for granted when they're living at home. So another reason why we really do want to make sure we utilize that as much as possible. But often child welfare does need your expertise and leadership in making sure that that occurs. So we've seen some nice collaborations in Philadelphia and other jurisdictions that if you are interested in that, we'd love to share more information with you.
So another underutilized but honestly quite essential resource for many young people is SSI, Supplemental Security Income. And just to give a little bit of a background into why this is specifically a transition issue for a lot of young people, is that there's eligibility is affected obviously by income, and federal foster care payments are generally considered to be income based on need, the type of income that would be considered for eligibility for SSI purposes. So what that means in practice is that for many young people, while they are in the child welfare system, they may be medically eligible. They may have been receiving SSI, in fact, before they entered the foster care system, but they aren't going to meet the income eligibility requirements for SSI while they are in the foster care system. And if it can, for some young people that only enter for a brief period of time and may have been receiving it before, payments can go into suspended status and whatnot. I'm happy to talk more in depth about exactly the interaction here. But the practical effect is that if you have someone who's in foster care for more than a year or that perhaps wasn't receiving benefits before they came in, even if it seems like a clear, this child has a disability and should be eligible situation, they may not yet they are likely not receiving SSI. And there are exceptions to that. I'm happy to talk more if anyone has further questions about exactly how the eligibility works. But for purposes of today, I want you to sort of understand how what ends up happening is that there are young people who are approaching discharge, and that could be for reunification, it could be for adoption, or it could be for aging out, who are not receiving SSI but who are eligible or who will be eligible. And we'll talk more about the particular challenges for young people aging out of foster care and the sort of risk of poor outcomes in a whole host of domains. But I want to really emphasize here that SSI can often mean the difference between homelessness and a reliable place to live for young adults who have aged out of foster care. That income stream, although as we know, not incredibly substantial, can be invaluable. But what ends up happening is if there's a delay in the application because of long application times and just the logistical challenges that many of these young people experience just in getting their medical records and in submitting a strong application, they will end up aging out or leaving the system without having benefits fully in place. And there is just no safety net there to catch them. This is the sort of, the delays in getting benefits in place can have really devastating consequences for this particular population. And so it can create a really high risk of homelessness even for people who have clear eligibility for benefits. Fortunately, there's been some advocacy efforts around this issue, sort of raising awareness of the fact of how devastating the gaps in benefits can be. And the Social Security Administration last year agreed to change their policy to allow foster youth who are leaving the child welfare system for any reason, it could be for reunification, adoption, or aging out, to apply earlier for SSI than their counterparts outside of child welfare. So they are allowed to apply 6 months before the expected discharge from care. And what an application will do is allow them to get a medical determination of eligibility, so that when they do then discharge and cease getting the foster care payments, they would be able to immediately receive SSI payments. And as I mentioned, it applies to youth leaving care for any reason at any age. So this is really quite a broad policy. It went into effect last August. It is technically a one-year pilot program, so sort of like Jenny mentioned with Medicaid of 26, it is something that we are hoping sticks around. But we do have some indications from the Social Security Administration that we have not heard anything to the effect that they're planning to change it, first of all, and second of all, I think they are attuned to the needs of this population and are invested in trying to see it through successfully. In fact, they've talked about some interest in providing additional trainings and whatnot on this policy. So if there's something that you're interested in your area, please let me know, and I can try to sort of connect you to who might be able to provide such a training. I think that they're interested in doing more outreach on this. It's also similar to the IEP transition planning process. It's an area where your expertise is incredibly valuable to your child welfare partners. SSI can be a really daunting and technical seeming area. You know, people sort of know what it is, but may not know the technicalities and might just sort of both the process and the eligibility requirements. And so it's a place where you can be a really vital resource to child welfare partners, both in helping with the applications themselves and just, you know, helping identify who might be eligible, helping sort of raise that question of, have you thought about SSI for this person? It might not be on the radar of people who are a little less familiar with the service system. Again, I want to highlight a tool that we've put together to try to help raise awareness of this and make it a little bit more user-friendly for child welfare stakeholders. This is a tool, again, it does sort of have a child welfare audience in mind, but I think it's something that, like Jenny described, you know, you are welcome to take and use and maybe have it be a reason to suggest a training for child welfare stakeholders in your area, or just to share with them, or to talk about, you know, how might we be able to figure out how to see this through in effective policies and practices in our area. So it's included in your handouts. I'm not going to walk through all of it right now, but it's got both basic information about the policy, including the legal citations. It's got a few other resources just to what is involved in an SSI application in general, and includes some sample timelines for when we recommend that materials be gathered and applications submitted. And it does include a sample demand letter for if you end up in a situation where the local Social Security office doesn't know of this policy, is resistant or whatnot. You know, it's sort of a sample legal document that you might be able to use to sort of call attention to the fact that this is something that an early application is now permitted. So if you have any further questions about that, I mean, feel free to chat them in right now too. I'm happy to answer any, but this is an area where we do have a lot of tools and resources, and we also have some local partners that we might be able that could help work with you if you're interested in, for example, doing a training on this in your area. You know, we have a lot of things that we might be able to connect you to help make that possible. So please do let me know about that.
And Karen, one thing just to add is, as Karen said, like SSI is so important for a lot of young people as they're discharging from the child welfare system. And I think child welfare has some knowledge, as Karen said, of like what the benefit is. But often what they don't realize as much, and you guys I think can be helpful in educating, is the degree to which SSI isn't just important because it is, you know, connected with an income source, but it's also connected with Medicaid eligibility, which former foster youth will have, but they'll lose that at 26. And then there's also, in many jurisdictions, you really need to get SSI to have access to certain programs, or at least it's a gateway to a bunch of programs that can help with housing and with other supports. And so it really just can lead to so many other support services. It's not an end-all and be-all, but tends to be something that holds together and leads to other portions of a good transition plan. And those are things that I think we try to reinforce with child welfare advocates, but know that you all are very well aware of kind of its interplay between a lot of different benefits and services. And so spreading that word, I think, can be very helpful. And just, you know, we do want people to feel the urgency that they need to know this is important, and that that if they can understand the importance of it, that they will kind of plan their action steps and their case planning accordingly, so that we don't miss out on those opportunities.
Absolutely. Thanks, Jenny. Similar benefit that can be vitally important, can be a really crucial building block in the array of services that can provide stable housing for a young person and supportive services that allow them to live in the community and not in an institutional placement, are Medicaid waivers, so the home and community-based waivers. This is, again, an area where child welfare partners often know something about them or know about their existence, but really need assistance with the technicalities of the applications, figuring out who's eligible, knowing when those need to begin, understanding the fact that many have wait lists. These are a service that does vary substantially by state. There's, you know, they're provided for federally, but what they're going to look like is going to vary significantly around the country. So it's a little bit hard to generalize as to exactly how you might be using them in your area. There are some states, for example, New York has the Bridges to Health program, which is a foster care specific Medicaid waiver program. We think that's fantastic. It allows for a lot more continuity of services, and it eliminates some of those challenges that you see listed on the slide here in terms of the applications and wait lists and knowledge gaps, because there's sort of a built-in structure for allowing child welfare involved young people to access those services. Unfortunately, that does not exist in many places. So, like, for example, here in Pennsylvania, there are a host of different Medicaid waiver programs, that many of which children are technically eligible for. There's not a lower age limit that would exclude foster youth, but due to sort of the way different funding streams interact and whatnot, many times they're not receiving that benefit while they're in the foster care system. So again, it becomes a transition challenge, a question of how, as somebody is leaving one service system, they're going to be able to be hooked up with these benefits. And I think many times, sort of understandably, when confronted with very difficult transition challenges for young people with complex needs, child welfare partners will look at these as being the sort of, if you can connect them to a waiver, they've got everything. And that may also not quite be the case, and they'll need to turn to people for expertise on what exactly are the services that you might be able to get through a Medicaid waiver. How are those analogous to what they're already getting through child welfare? There really needs to be a dialogue and an interplay between the people who understand what the young person is receiving through child welfare and what their needs are, and what's possible through these more, quote, adult serving systems. And I think Medicaid waivers is one area where this really comes out. And so early planning, collaborative planning is really essential. And we'll talk more about some strategies for making that possible. But I just wanted to highlight again, a legal hook, a service that exists in many places that needs to be considered in tandem or in parallel with child welfare requirements.
And Karen, just one thing to note, and we've confronted this a lot, is for you guys in the protection and advocacy world, you're very familiar with Medicaid home and community-based waivers. You know that acronym. The term waiver, is a term that's used in a lot of different areas. And in the child welfare world, there's often things, there's a Title 40 waiver, there's a lot of different things. A lot of people in child welfare really aren't going to know what a home and community-based waiver, Medicaid waiver is. And it's okay that they don't, because it often, as Karen said, it's often that youth in foster care aren't being made, that they're not having access to these waivers until they leave the system. We don't have as many states designing waivers for foster youth. So do know, just as kind of a basic matter of education and vocabulary, clarifying what those things are, as well as kind of what they are, what you have in your state. We're going to introduce you to a resource we did in Pennsylvania that gives you a structure for how you might explain what is a home and community-based waiver, and then go through kind of ways you might explain it in terms of what you have in your state. But definitely, and I know we all confront this in the different worlds we work in, of just translating some of our known quantities and vocabulary. And this is when we have really found that it is important to explain and not want to assume people know about. You guys are aware of it and probably are aware of how complicated it is, even when you know about it. But just knowing that this is a point where really providing that education and shared information can go a long way. And then you can get to the also complicated task of the coordination. But definitely we have found that we have wanted to share more information, talk about what these concepts are and how they're different from just Medicaid coverage itself, which foster youth have, and when young people can access them.
Thanks, Jenny. So finally, I want to spend a minute on talking on vocational rehabilitation. Again, it may be called different things in different states. OVR is what we refer to here in Pennsylvania. But federal service that exists to help individuals with disabilities gain skills and connect to employment opportunities. Something, as is becoming the refrain for this section, that child welfare advocates are often aware of in some respects, but are not as versed in as would be helpful or as you would be. So there can be a challenge to sort of maximizing the benefit that's possible for foster youth through these programs. I want to really emphasize, and this likely is something that you guys have heard a lot before, but it can be, it's such a vital benefit that I do, and it's also an opportunity for partnership that I want to spend a minute on it, which is that under the Workforce Innovation and Opportunity Act, the 2014, WIOA, as is affectionately called by many, there's a really heightened focus on youth services. And this is true in all of the titles of WIOA, so both the sort of general labor provisions governing the workforce investment boards and sort of labor services in general. There's a new focus on youth services, and that is also true for vocational rehabilitation. So now VR agencies are required to set aside at least 15% of their federal funds to provide pre-employment transition services to students with disabilities. Both of these terms are defined in the regulations governing the statute, and both of them are things that would be both include individuals in foster care and can be very beneficial to them, and there's a lot of overlap between the idea of providing pre-employment transition services and providing the types of transition services that are mandated under child welfare law. So just to give a little bit of more detail on what we mean by this, pre-employment transition services are designed to assist with the transition from school to competitive integrated employment. And there are required activities that must be happening in all states, and at this point, the regulations, everything's fully, well, not necessarily fully implemented, but fully, the requirements are all in place now. The 5 required activities include both sort of counseling, sort of group trainings and things that help hone in on potential job readiness skills and career opportunities, as well as actual work-based learning experiences. This can be paid work experience. And so we've seen some really exciting things happening in our area, and I'm sure there's a lot of things happening around the country as well, where, for example, traditional child welfare service providers have become newly approved as an OVR provider to be able to offer work-based learning experiences using WIOA money. And that is exactly the answer of an example of the type of collaborative, sort of cross-disciplinary approach to providing really customized, individualized services to a high-needs population at the point of transition that we'd really love to see. So I'm happy to share more information about that particular, it's really a sort of new program, so I don't have that much detail, but the idea of child welfare providers or child welfare facilities or even juvenile justice facilities becoming OVR providers that can offer these types of things to this particular population is sort of a new opportunity in the law that could result in some really creative programming in your area. So for all of the services that I just talked about, so IEP transition services, SSI, Medicaid waivers, and vocational rehabilitation, these are all services outside of child welfare, but they really, we would argue, are connecting to those services should be part of the transition planning process through child welfare. It should be built in, having timelines, and we'll talk in more depth about what this might look like in practice, but making referrals, submitting applications, connecting to these services, identifying the needs that young people have that could be met by these services should be a component of what child welfare transition planning is, but it requires the expertise of these other systems and coordination with these external systems in order to make that possible. And so again, the key advocacy role for you that we would love to build upon. So with that, we're going to talk about, so that's the end of the part section of the presentation focused on the legal requirements. So if you have any questions, I'll pause for just a moment. Anything that in Ginny's section about the child welfare legal requirements or what we just covered outside of child welfare, are there any questions that you'd like us to address before we move on to talking about barriers to transitions and advocacy strategies? I'm not seeing any come in. I know it takes a minute to type, so I don't. But we'll move on at the moment. But if I see anything come in the next 2 minutes, we'll take a pause to answer those questions. And I actually have a question for you, which I apologize. I forgot that was coming up here. Which are there any transition challenges that you have experienced when working with child welfare involved clients? This is actually pretty much the same question I asked you at the beginning, but now that we've talked about it a little bit more, does anyone have a particular challenging situation that you've encountered? Something that shows, what makes working with child welfare involved clients particularly hard? All right, we got some brave souls here chiming in. So children have poor experiences with the child welfare system and no longer want anything to do with the system and its supports. Absolutely, we have seen, yeah, that's a really common challenge that we've certainly seen in a lot of different respects. It comes up a lot in our extended foster care work because once you get past 18, obviously deciding to be in child welfare is no longer, is something that young people are deciding to do, and the poor experiences in the system can often lead people to sort of opt out, understandably. So we'll talk a little bit about some implications of that.
And one of the trends, which has always been in the special education law, but as we let you guys know, the kind of pushing down the age in terms of when child welfare thinks of transition, why we wanted to highlight kind of some of the increased focus on involving young people and also letting young people select people who they care about or who are important to them as part of their planning, is one way. If you are lucky enough, because I know that often you guys probably like us, we get alerted to some of the most problematic cases when it is 18, 19, 20. If you are able to think about either in a systemic way or through the luck of a case that comes your way, really getting involved in planning as early as possible and using some of the law we told you about to really, you know, in my opinion, work your way into the planning process, because we want kids to be engaged in their planning in part because we want them to, you know, be able to voice their opinions and their preferences, but also we do want to make sure the services they're getting are the right ones and that they're part of these decision making, because we do think the issue of engagement and choice are so crucial and what then helps us build that transition plan. Because as the participant said, I mean, there's so many youth where there is just such a resistance to any type of service because of their bad experience in child welfare or other child serving systems. And so I do think engaging youth and really the degree to which we as advocates can help make them part of and influence how the planning is done is one way to combat this. It's very hard because I think in large part that is a systemic change, and often many of us on the call work on that, but often you guys are getting the call about the individual case, and it's often at a time where you can't go back 2 years in time and figure out how to do that. But it is something worth thinking about, and I do think about protection and advocacy agencies as such leaders in person-centered planning and really focusing on how we get the voice of the individual out. And if you can help us as child welfare advocates figuring out how to accentuate that and make that more possible in child welfare, I think that is one way to engage youth in a way that makes the service delivery better, so it is something they actually want and will help us with the planning. So I'm glad you brought that up, because that was one I don't think we specifically identified in the PowerPoint, so I'm glad you brought that up. I think it's a reality and a challenge for all of us.
Thanks, Jenny. And a couple other people have chimed in here. One was a question actually about special issues regarding children moving from the child welfare system to the juvenile justice system. Absolutely. I mean, crossover youth who are actually simultaneously involved in both systems, also the handoff of providers or of, you know, the system stakeholders that might be serving those youth present, you know, the same types of challenges, but, you know, there's perhaps different requirements, different pressure points when you're dealing with that particular transition or that particular handoff. So I guess we could share, you know, if there's particular difficult situations that you've encountered or you want to talk more about how to handle a particular aspect of that, please feel free to send an email or we can talk more about that. But definitely.
And I mean, Karen, I think one issue, and we're happy, and this is where we do think there's a lot of opportunity for collaboration between P&A advocates and child welfare attorneys and advocates, is that when often I think P&As are called when a kid in the child welfare system is arrested and they're sent to the juvenile justice system, and you find that there is an underlying issue related to disability. Either the action or activity was related to either something that was part of their disability or a failure to provide that kind of treatment, and often you're getting the call after that has happened and really trying to figure out what to do now, but also trying to figure out, you know, should this have happened at all, and how do we make sure we leverage to the degree we can the child welfare system to keep that young person there, not be sending them to either the juvenile justice system or adult criminal system. For some of these kids in extended foster care, that's something that happens. So we do see that meeting the transition needs of kids in child welfare is a way to avoid these things from happening. But definitely, we really encourage you, if you at P&As are getting these calls and really see them as related to kind of a lack of appropriate treatment based on the disability or service delivery, those I think are really great areas for collaboration. And we're going to talk in a second about kind of policy remedies, but also some litigation opportunities that might be related to situations like that. So I'm not sure if that's one of the things the participant had in mind, but that's something that we definitely see a lot, and really are open to hearing from you all and brainstorming, and also trying to make some connections in your state with some child welfare advocates that might be interested in partnering either on a policy or litigation response.
All right, so I think we're going to move to talking a little bit more about the challenges that we've seen, and I think that probably some of these will sound familiar to you as well. So I'm going to let Jenny talk about it. Thanks.
And I think, you know, the barrier one kind of unique aspects of foster care status, I think to some degree, although I wasn't thinking about this, and I'm glad the comment was chatted in about just, you know, the unique status of being in foster care and being system involved really does put a challenge for all of us of if a youth really has had a bad experience, both with treatment and just services in general, that's a challenge for all of us in engaging them in transition planning. And some other unique aspects that we just want to point up that seem like important for P&A advocates is that, and we've talked about this throughout the series, is that a lot of the things that you might take for granted for youth who you're getting calls about, usually by a parent, that you're going to have to be mindful of things that are different, and some of those differences are going to make your advocacy more challenging. So often the beginning of your call is by a parent, and the parent is really identifying a problem and really is moving the advocacy or trying to drive the advocacy and get your help. And that's not always the case in child welfare. Often you are getting a call from someone who has a concern, but you might have that missing piece of the parent. Sometimes you do have them available, so that definitely is the case, but sometimes you don't, and that can bring up some challenges for your ability to take certain action. So that's definitely an issue and something just to be aware of as you are trying to help with building a transition kind of system and also providing advocacy. The other thing that's just important, and this is probably something you all are very aware of, but you know, again, when you get a call from a parent of a child who's transitioning, they're often really wanting you to help with connecting with services, but in a lot of those cases, the young person is living with the parent. In child welfare cases, almost in every case you're working on, where they're going to live is an issue because they are getting their source of housing and placement from the child welfare agency. So again, something to be mindful of, not a barrier you can't overcome, but definitely complicates what you're working on. And there's definitely tons of different unique aspects of foster care that I think serve as barriers to creating a good transition system, but those are some of the ones we wanted to highlight and want to be looking at working on with you all, as well as kind of partnerships between you and other child welfare advocates. And the barrier too that we're looking at, you know, you guys know this very well, this is the case not just for kids in child welfare. I think it's a little more accentuated because of not necessarily having a parent kind of driving the case as much. This planning is just not done early enough. Even, you know, we do have laws, as we mentioned, to encourage and really require that planning earlier. It really doesn't happen early enough, and we see kids suffering and falling through the cracks. And this is always really a shame to a lot of us because we're talking about planning to connect kids with things that exist. We know we don't have enough of what kids need, but we at least have to make sure they're connected with the things that exist. And when we don't do that early enough, we really do, kids really do lose out. And often what we see, and you guys see as well, is when they're not set up for the Medicaid home and community-based waivers, when they don't have SSI, they really are at risk for being homeless. They're at risk sometimes for institutionalization. And of course, those are things we work hard to challenge immediately, but definitely things that come to our attention because of a failure to plan early. Barrier 3 probably is the biggest challenge I think we all address, is that we really don't have, and we're happy to hear if you guys have some good examples or models that you've seen, but we really don't see kind of statewide, jurisdiction-wide clarity on what the planning obligations are for each system, and really clear systems for who does what when, and accountability. And that is often just our biggest challenge and biggest frustration. If someone thinks someone else is going to do it, There's no accountability in who does what. There's no timelines. And again, it's kids who are really losing out, and I know you guys see that as well. The other barrier we really do confront is a lack of providers who, I will say able, but also have the expertise to work with transition age youth. We definitely see cases where a young person is eligible for certain benefits or services, and providers are really reluctant to work with this young adult population. And that, again, is a huge challenge, and one we think we should be able to overcome, but definitely one that I feel like is holding us back in terms of successful transitions. So these are some of the big barriers we see. I'm sure there's more. We don't want to overwhelm everyone with barriers, but definitely want to hear more from you guys if you're what else you're seeing. But these are just some of our kind of most common challenges.
And we will talk a little bit about ways to
yes.
alleviate these. So it's not just going to be a downer talk here. But before we get to that, I want to talk for a few minutes about what this might look like in an individual case, which might also get you guys thinking a little bit about some examples you've seen. So the names have been changed, and these are, sample pictures, but these are actual individuals that we have worked with here in Pennsylvania, and I want to just highlight a little bit about their stories to show the way these things can play out. So Brendan and Sean have some commonalities in their cases, which is why they're sharing a slide here. Sean, but both of them we were working with kind of on the eve of discharge, as I think often happens with you guys as well. You get a call when there's almost a crisis. So we were not working, unfortunately, with these people for a long time before transition. We were trying to sort of facilitate things right at the 11th hour. So Sean was, doing really well, actually. So he's longstanding time in foster care and also longstanding diagnoses of ASD. He was on the spectrum, and he had mental health, some behavioral health challenges, and also a mild intellectual disability. And he was in a therapeutic foster placement. So this is a family-based specialized foster arrangement paid for through the child welfare system with some Medicaid support. With a really supportive foster family. He was on track to graduate from high school. He had plans to become a welder. And his foster parents, they weren't able to be a permanency resource, but they intended to continue to care for both him and his brother after they aged out of foster care. So they would continue to be a sort of housing resource and support network for the two boys. But unfortunately, sort of because in some ways everything was going just fine from child welfare's perspective, there had not been any effort to connect him to the services that might continue to make these things possible after he aged out. So he had not been registered with the Intellectual Disability Services Agency here, which is a necessary first step both for ID services in general and also sort of more vitally for the Medicaid waivers that you might be eligible for if you have an intellectual disability in our state. And there had been no effort to begin an SSI application. And so the foster parents were realizing that they were going to lose a tremendous support structure, financial support and otherwise, once he aged out of foster care. Their maintenance payments were going to cease, and they weren't going to have the same, supervision and sort of respite opportunities and things that the foster care agency was providing at that point.
Including Medicaid.
Including Medicaid, yes. Although he was receiving well 18, so he should be able to have 20 till 26. But then at that point, we just kicked it down the road. So, so this is someone who everything has been going great. As Jenny had mentioned, it's kind of there are existing services that could help him, and he could have had a sort of form of permanency through an ability to have a really stable housing situation and continue his community-based existence. But instead, he was at a crisis point. So this is one where, of course, we all just really want to have been able to backtrack and go back in time and start these things earlier. But it highlights sort of why the need for some of the policy measures that we're about to talk about in terms of really, looking at what the transition planning protocol is and identifying who the contacts are to make sure that these things get started and that you don't end up in a position like this where sort of due to a confluence of sort of lack of knowledge by the relevant stakeholders and just, lack of having sort of systems in place that make clear that you need to ask these questions, there's sort of an unnecessary problems created. So fortunately, just to give you the ends of the Sean's case, like his foster parent, there was a delay in getting benefits, but because he was eligible and we were able to step in, and with the assistance of the Protection and Advocacy Agency here, we're able to get kind of expedited applications going for some of these things. And so because he had stable and supportive adults in his life, the gap didn't result in the type of consequences like aging out to homelessness that we might otherwise see. Now, unfortunately, Brendan's case is the counterpoint to that. So Brendan is an example where he had a longstanding ID diagnosis, very similar to Sean, but he, instead of being in a community-based, family-based environment, he was in a group home for a long time, sort of tracked on their ID course. So he was in a like cottage for all young people who had some intellectual disability. From child welfare's perspective, he was being taken care of. He had an ID diagnosis. He'd be able to get ID services when he aged out. And there was not a lot of investment in his independent living skills or in his vocational training or in his education. There was a sort of an expectation he was going to get served through the adult system. Well, right on the eve of his discharge, there was a re-examination of his diagnosis, and the ID agency questioned whether he was, in fact, eligible for services. And we sort of had two service agencies pointing fingers at each other as to whose fault this was. But a young person really caught in the crosshairs of that and looking at the very real possibility of aging out to no living arrangement, to homelessness, and not just to homelessness, but to lack of any sort of support structure, potentially lack of health insurance. And again, sort of rather unnecessarily, especially once, again, to fast forward in his case, there was a renewed, he got an additional evaluation that demonstrated he was eligible for services, and through a lot of really robust advocacy by his attorney, he was able to be able to be connected with ID services quickly enough to avoid a discharge to homelessness, but it was through some lots of making of exceptions as opposed to following a protocol or practice. So this is just really to highlight the potentially catastrophic consequences for failure to coordinate planning early on.
And I think Brendan's case also shows that, as Karen said, this lack of coordination and just these young people aren't being prioritized. And when we look at Brendan's case going backwards, so much time where there really wasn't attention to what he needed, and him making the idea that he could and should make progress, should be connected with the community. And these are the types of cases we know you guys on the phone, you know, if you got a hold of, you could really help child welfare advocates very early on figure out, no, he doesn't need to be in this placement. No, we need to work on, you know, engagement with the community. So definitely this case really does highlight a lot of problems with the transition system that we set up, but also things we talked about in previous webinars of just kind of overuse of group care for kids in child welfare. So these are definitely the cases where we can use your partnership to make sure that they're really addressed way even before transition is an issue. But definitely when we see it's not a rare case, really sadly, it's not a rare case.
I'm seeing a comment come in, which I think is a really key thing to mention, which is that, just to read off what the participant is saying here, we often deny requests for evaluation by schools as the child is approaching graduation for fear something will come up. A two-edged sword for sure, but we've seen kids get screwed by evals at age 17. Absolutely, right. And so I think it sort of highlights the technicality of some of this. Like, I have also seen that where somebody who had recently had a psychiatric evaluation, they had it done. For whatever reason, there was a decision to make it to do another one, and this is sort of outside of my expertise, but my understanding from the disability advocate I was working with was that, you know, sometimes repeating that type of evaluation, the child has just taken it. They're going to be a little better at literally the test in a way that isn't necessarily going to reflect their increase in skill set or anything like that. And so that's something again that child welfare partners often have a lot of trouble understanding or navigating or having tools and information to understand. And we haven't talked about it in great depth on this webinar, but getting the right evaluations at the right time and having a full, you know, the appropriate medical records in place is a huge challenge for child welfare involved kids. You know, there's the logistical steps of people move, records get lost, things aren't properly documented. They may not be getting the evaluations, or they may have gotten them and they aren't properly documented in their files. So all of this requires a lot of pre-work, and so and then you know, it can be very frustrating at the 11th hour to try to get all of that in place. One other thing that we're going to talk about this a little bit more depth later, but in terms of legal strategies, the only thing actually that made Brendan's case possible and not to have him age out to homelessness was because the court here in Pennsylvania did not refuse to discharge the case. Even though he turned 21. So he ended up remaining under juvenile court supervision with the child welfare agency ordered to continue to pay for his placement beyond the age of 21. And we'll talk about some legal strategies to try to seek that type of remedy or that type of situation in different areas. It depends a little bit on your state's law, but that's the kind of thing that sometimes these lack of planning cases result in, is that there's just simply not enough time without an extension of jurisdiction. So another case that highlights a sort of slightly different domain of this problem, and I apologize that all of these examples involved individuals with intellectual disabilities. We're certainly talking more generally, not just about children with intellectual disabilities here. The reason that they often highlight, these cases here in Pennsylvania often highlight some of the real transition challenges, is because we do have waivers available for individuals with intellectual disabilities, so that's sort of there's existing service systems that could be connected to, but these challenges are not unique to kids with ID. So this is someone who had both mental health issues and an intellectual disability. She's been with a foster mother for a long time. When that foster mother moved out of state, she was essentially dropped off at the child welfare agency, and they placed her in a group home where she was the oldest kid there. Nobody else had anything similar needs. It was sort of not an institution equipped to meet her needs. And fortunately, she had been connected to our ID system, and so had a very, very great supports coordinator who knew her really well, who understood her needs, who flagged this as being an issue, called attention to her situation, and identified a provider through the ID system who had beds available, who would be able to meet her needs in a community-based way. It was with her and one other girl who would be living in a family-based environment. And this was a systems issue. It was ID and child welfare had a lot of difficulty working out whether that placement could be funded or paid for through the child welfare system. And whether it was appropriately licensed to be able to serve the needs of a kid in child welfare. It was a really frustrating thing to be able to see essentially a strong both transition plan and almost permanency plan of something that would be able to provide continuity for Maya as she spent the last couple of years in the child welfare system and then left that system to the adult serving systems, but without the sort of abrupt change in residence or service array and things that you often see at that point. But because there wasn't sort of a formal understanding as to how ID and child welfare might coordinate, so how you could have somebody who's still involved in the child welfare system but living in an ID placement and receiving service arrays that might not be traditionally what's provided for through child welfare, she remained sitting in that inappropriate group home for months after she should have been able to move to a place that had a bed identified for her. And it took some real court advocacy actually on the part of our PNA here to be able to sort of carve out an extraordinary funding mechanism and exception to a licensing requirement to get her into a new placement. And this is sort of in some ways a more ideal situation than some others we worked with, because there was a provider here. As Jenny mentioned, a barrier can often be that there's simply not somebody there's not a provider existing in that area that that works through either like the mental health agency or the ID agency and specializes or is able to meet the needs of transition-aged youth. And so here we had a provider identified. In many instances, that itself would be the barrier. Anything else you wanted to say on some examples? Okay. All right, so we're going to move on to strategies. Jenny's going to take us from here.
Sure. And I'll go through this really quickly because I think this is something you guys do all the time, and we just encourage it. And we at Juvenile Law Center, and I know NDRN would like to support you on kind of forming these collaborations between PNA and child welfare. We think they can be really effective and really key to understanding the needs that kids have as they transition when they have disabilities, and really figuring out how to make a system that works. So, I mean, the first place to start, I think, is education and training. I think there's so much knowledge that needs to be shared so that people really can understand that this is an issue we need to address, both in terms of understanding what kids need as they transition. And I think one of the things we always like to do in training is really remind people the difference between adult and child serving systems and some of the different rules. And of course, a lot of this stuff is going to be specific to your own states, but think about kind of, and you guys in your own organizations might have teams, child and adult teams, really kind of understanding, particularly in the child welfare system, things that people really rely on and think of, well, if you're eligible for X, you get X. There's not waiting lists. Sometimes there are, but, you know, there's a lot of things that when you work in child welfare, you really do rely on happening and a young person getting if they need it. And really, a lot of times in the adult system, You really need to help people understand the types of planning that needs to happen, the waits that might occur, and also that we don't have as many entitlements, and that being eligible and needing something doesn't necessarily mean you get it. And so what is the planning and the things you need to have that need to happen to make that possible for a young person when they do age out? We also really encourage, but we know you guys are doing this already, collaborating on individual cases. We went over a little bit in this webinar, but have in previous webinars, and I think we'll have them all available for you, just some opportunities that the child welfare system provides for you in doing advocacy, both the case planning meetings, the transition planning meetings, but also we've mentioned court a lot. One really key opportunity for advocacy is these court hearings, and the authority and power of a juvenile court judge is so important for us. The law really does allow judges to order a lot of things, and when things aren't going right in terms of planning and service delivery, we really, really do need that sometimes. But often you guys in the P&As can help child welfare advocates know what the ask is, know what needs to happen next. So we definitely encourage this as a really powerful strategy that can often be step one to a lot of the things we're going to go on to right now. So another strategy is really just developing planning protocols. Our ideal, of course, is that planning protocols are in policy or law so that there is real accountability and enforcement. But we understand that that's not possible in all of our jurisdictions, and sometimes it would just be establishing a common practice that we try to get stakeholders to utilize. So we're going to talk about one example we do have about a protocol being in law is in California. And so California has a couple of laws, and this slide gives you the citations, AB 1633 and 1331, that really put in law a requirement about screening young people in child welfare for SSI, and also requiring that certain actions be taken so that the funding stream that their foster care placement is funded with doesn't impact, or actions are taken so it doesn't impact their eligibility. So we really think this is a great example of having a law that really does force the planning we think is needed to happen to get kids ready. And we would encourage, this law really focuses just on SSI, but we definitely could see laws that are modeled in this way that require other things to happen at 16, 17, 18, and 19. And you guys can be really key in working with advocates to say, if I was going to put a model policy in place and we could get it in law, what would I want to happen at 16? What needs to happen at 17? So this is an example we have of a law, but we could definitely see other components of it, and would love to have the legal protection of it actually being, enacted to help us move practice. This next slide gives you more detail exactly of what the California law does. We're not going to go through in detail, but if you're interested, we really do think this is a great example of getting the nuts and bolts in a law so that we really know that these things are going to happen and don't leave them to chance and kind of individual casework. If you're not in a position or have not yet been successful, and I will admit that that's us, we have wanted to get a protocol in law for many years. We still want to work on that. But what we did is really try to develop a protocol, encourage people to use it. I don't think we're running a little late, so we want to give you this link, and it is in our we're okay? Okay. So we're going to click really quickly. We created a protocol. It's really a planning tool that you could use. It's targeted at child welfare cases. It could be used, I think we're aiming it at child welfare systems and agencies using it, but it was developed with a lot of stakeholders, and particularly with the expertise of our protection advocacy agencies in Pennsylvania. And it's trying to guide, and prompt you to ask the questions we think are essential for transition planning beginning at 14 and going up until the point of transition. We're happy for you guys to use this protocol. We're happy for you to use it as a beginning and edit it based on your own kind of state needs and things that you think would be most successful. We're definitely would be excited if you improve it to share it with us, because we'd like to learn from others. But this is just one way of developing a protocol and trying to get other stakeholders in your community to use that protocol as well, so people have a kind of common understanding of what should happen, and using that as a way to develop kind of expectations on practice. It's definitely not as good as having a law, I understand that, but we're always kind of looking at different ways to try to impact how people would do this, so that the right actions are taken, so kids do end up kind of in the best situation as they transition.
And this protocol is one of your handouts also. So in addition to being downloadable on our website, it's also just there in the sidebar of the presentation. Okay.
And another thing we've seen, when we did this transition planning guide, a practice guide, Advocates in Florida also did a great one that we used as a model for ours as well. Developing these guides, which really take you through what are all the things you need to do as you are transition planning for youth with disabilities and child welfare, that these can be good both in the same kind of goals as developing a protocol, to develop common practice and expectations. But also we found, and I think we learned this from the Florida Advocates as well, the process of developing it and then doing some training on it is another way to really educate stakeholders across systems and provide, again, a kind of common language and at least a place to start some of these conversations. We're happy for you to utilize ours as a model. Again, we don't think it's perfect, so as you use it and edit it and make it better, we'd love to hear from you because we'd like it to be as useful for our state and for other states as well.
So another strategy, and this is rather overlaps in some ways with the notion of having a protocol, and there's some similarities, as Jenny mentioned. This is designating points of contact at different agencies. You see this in some of the barriers we described earlier, where an obstacle to getting services in place is simply not necessarily knowing who to call or not knowing which agency provides which services. And having just a key point person that's in a somewhat formalized arrangement can make a real difference there. You've probably all seen in different examples in your own work, if you know the go-to for something at a particular agency or organization, that can make a world of difference in getting a service in place. And so it's something that can be possible through, formal agreements, memorandums of understanding between agencies. It could even theoretically be in regulation or law or part of a protocol that might be in law somewhere. But it can also be something that happens at a much smaller scale or much more informal way, and where there's simply meetings that take place, for example, with the local ID agency that results in someone being the designated child welfare point person, that knows a little bit more about the issues those kids face and is the one that's going to receive those applications and those phone calls. So the more formalized, I think we would say, the better. But just even small steps can make a big difference there. And one way that you might advocate for this type of thing, we're sort of still experimenting with this in Pennsylvania, but we're a little tight on time, so I might not walk through. Well, sorry, I will walk through this example since I don't have a link to it otherwise. We did a survey of a bunch of providers in our area that serve child welfare involved youth, that asked a bunch of questions about different. It was part of a preparation for a housing program, and this is often the way these challenges come up, is that you have understandably a real concern and need in the child welfare world of better housing opportunities for kids with disabilities. And as we've discussed, there's a lot of building blocks that make different housing arrangements possible. There's not really just like a one-size-fits-all answer there or one service that will provide all of it. So what we did is we surveyed people on where they lived, what agencies, the different types of agencies that they might contact, and then we asked, do you have a designated person at that agency who works with young people involved in child welfare or juvenile justice, and what's the name of that person? And we did this in print format too, where they would have had to sort of fill in what the contact information might be. And doing this served two functions. First of all, it was information gathering. If somebody knew that information, that's great, and they can share it with others, and it can become part of what we share with others as well. But by and large, you might not be surprised to learn that people didn't know who that was or didn't have somebody identified, and it helped demonstrate the need. And so this is, again, something that you can model, something that you can probably improve upon, but can help be a first step toward the types of advocacy that might actually see something more formal put in place.
And we're happy to share that that survey with you guys if you want to use it. Many people have SurveyMonkey now, but we're happy to share the questions we asked.
Absolutely, and we do have, I think we have them in a Word document too, if it would be easy to share. Another basic strategy that could help implement many of these types of policy changes is forming advocacy coalitions. We really rely on the expertise of different disciplines here, the education system, the mental health system, the disability advocacy world, the child welfare service systems. And so partnering in your advocacy efforts can be really powerful. And there's a few examples of how that's been true here in our state. So the Imagine Different Coalition, this is actually a statewide effort. It's a broad coalition of disability advocates and child welfare partners and some healthcare providers, all focused on reducing congregate care for kids. And because we've sort of come together as a multidisciplinary entity, we haven't seen as much change as we'd like to, but we have been able to submit some very specific recommendations about how to improve access to Medicaid waivers, how to improve access to medical foster care for kids, and that has resulted both in a series of meetings with the relevant cabinet secretaries and having sort of a cross-disciplinary conversation within our department, our statewide Department of Human Services, which is itself a hard thing to achieve sometimes. We've gotten better data on where the particular challenges are. And we've been able to submit kind of unified comments where there have been opportunities for commenting on proposed regulations or laws. And so we're hopeful we'll see more change, but it's been I would say, a successful effort so far, at least in calling attention to a problem that requires interdisciplinary attention. On a more local level, we have a small coalition of again, healthcare providers, child welfare stakeholders, disability advocates in Philadelphia that have really been able to, we sort of hosted a meeting that allowed us to really robustly describe the challenges in our area, which again is kind of a first advocacy step. You know, if you've got a good lens or a good description of what the barriers are, that can help initiate policy change. And so we've moved from sort of articulating what the challenges are, really describing them in a sort of data-driven and strong way to be able to have that translate into a white paper that has policy recommendations that we hope will be implemented. Finally, this we've alluded to a number of times, and I have a little bit more detail in these slides than I think I'm going to be able to talk about right now. But there are, the dependency court's jurisdiction allows for legal strategies to ensure that services are in place for individuals, even potentially after cases would ordinarily be closed. So we mentioned that here in Pennsylvania, there have been instances where the juvenile court has, because we have a requirement that a transition plan be approved before a case can be closed, where the transition plan does not satisfy the judge's criteria for that or within the court rules for that, the case can't be closed, is sort of the inverse of that. And so cases have remained open beyond where jurisdiction would ordinarily cease. The Dustin R. case here is another sort of a similar example, and it's one that that resulted in an appeal, and so got a decision that could be useful in your areas, and actually ultimately now has resulted in the legislative change to codify the holding. But here it was a situation where the youth was committed to both child welfare agency and the mental health agency. There was a family willing to provide services, and there had, before the child approached discharge, there had been a hearing where on the record it was established what the level of services were, and finding that the setting in the community with that family was the least restrictive setting for able to meet the child's needs. And so the court, before the child approached the age of discharge, ordered the current level of services to continue at that level. And the holding of the appeal was that order could persist. The mental health, the court's order requiring that services be continued to be provided after age 21 was enforceable. That the scope of, and it was sort of utilizing the broad scope of the juvenile court's jurisdiction under state law, and then sort of common law parens patriae authority to provide for the best interest of the child, to allow for to enforce the order requiring the mental health agency to continue to pay for services. So just something creative to think about, push the limit of the court's authority, really enlist the support of the court where necessary to ensure that services are met and the kids' needs are met. So,
and we really did see those cases really were pushed, I think, as a result of really good partnerships between child welfare advocates and the local P&As. So they really do show how those collaborations, I mean, in this case was just great because they did follow up with legislative codification. As Karen and I mentioned, I mean, some of the cases we're highlighting did have some helpful state law, which did either require, a transit court approving a transition plan, but we definitely do have some examples and at least have some ideas of, we still think it's worth pushing courts to keep cases open if there isn't an appropriate transition plan. And as Karen mentioned, this just authority of the juvenile court, whether it be equitable or parents patriae, this idea that the juvenile court can continue jurisdiction, create orders that are in a child's best interest, do give us some leverage to argue these cases even when we don't have specific transition planning requirements in states. So again, like, I think those are great opportunities for P&As and child welfare advocates to partner, as well as on legislative and other policy initiatives that Karen mentioned. We're happy to help make some of those connections. If you guys, any of you all on the calls are looking for advocates from your respective, whether it be P&A or child advocate or child welfare organization, we know we have a varied audience today. If you're interested, we'd really like to help support you in working together and also sharing any of the information for you to use that we presented today.
It's also a good example of how partnering in an individual case can result in broader policy change. So, you know, by pushing the envelope on this particular child situation, there was not only ultimately an appellate court decision that had broader effect, but also legislative change. So really encourage you to facilitate those partnerships. I apologize that we ended up with not enough time to really be able to take questions here, but here are our email addresses. Please feel free to reach out, ask any questions you have. There have been a few that have come in the chat box that I'll follow up with by email. And we really thank you all for your attention today, and to the National Disability Rights Network for supporting this program. And we will, as Jenny mentioned, this is the 4th in the series, and we have recordings of each of them that we will make available.
Thanks very much.